Speaker of Parliament Alban Bagbin took aim at the judgment of the Supreme Court that stayed his ruling on those 4 seats. He asked his lawyers to file an application to get that set aside. But even before that argument will be had in court, his lawyer was on his feet in opposition to one member of the panel, Justice Yao Enes-Gayeu.
He was known to be associated with the New Patriotic Party. And in fact, he was a parliamentary candidate in one of their constituencies in the Volta region.
I think you said enough.
Very well. And
yes.
I just want to demonstrate from, especially again.
No, I think you said enough.
From the
I think you
proceedings.
said no. I think you said enough. Kindly resume your seat.
Very well, Malik.
After listening to the arguments on both sides, the Supreme Court, the 5-member panel, did not agree with Thaddeus Sori, lawyer for the Speaker, that Justice Yao Enes-Gayeu should recuse himself from the case.
This court must take judicial notice of the fact that within the ranks of the Superior Courts is a former member of Parliament for the National Democratic Congress, a former General Secretary of the People's National Convention. The subject matter of this suit before this court is a constitutional dispute and not a matter involving political parties. The objection is therefore misconceived. Move your application.
The court then zoomed into hearing the substantive case. It first heard from Thaddeus Sori, who raised a litany of issues with the judgment of the Supreme Court, which he said should convince the same court to vacate that earlier ruling.
The writs or the processes on the basis of which the court's jurisdiction was invoked for the order are void because they were filed in violation of the rules of the courts. That irregularity is incurable. That even if it were curable, which it is not, the court's jurisdiction, substantive jurisdiction, to entertain the matter as a whole was not properly invoked.
The Attorney General himself actually did come in and raise some points of law which he said simply made the case of the Speaker of Parliament untenable.
Whenever a decision of the court is being sought to be reviewed, varied or discharged, the procedure for doing so is as set out in the Constitution. And this is not an invocation of any of those procedures.
After hearing these arguments in court, the 5-member panel unanimously dismissed the position that was canvassed in court by the Speaker of Parliament and his lawyers.
We have considered the application and find that the grounds supporting the application have no merit because of the very explicit and clear directions of the 1992 Constitution, specifically Article 2, Article 130, and Article 296, and established decisions of the Supreme Court from decades of the country's constitutional history.
The court has now adjourned to 11th November to hear this case again, and the expectation is that on the same day, the court will hand down its judgment on the interpretation of Article 97, 1G and H, which talks about whether or not if a member of Parliament decides to contest as an independent, for the next election, he vacates his seat, and also whether or not an independent member of Parliament who decides to join another political party and contest on the ticket of that party for the next Parliament also loses his seat. Reporting for Joy News, Kweku Asante, Supreme Court, Accra.
Judge starts speaking, you stop. Do you not appreciate that?
So, my lady, I don't think my lord thought I interrupted him. I was just responding.
I beg your pardon.
Then you shall. It's a front, I don't speak.